Good morning. This is Rajeshkumar. Today, we are going to analyze one problem question with related to the Criminals Attempt Act 1971. The video content has been made available for informational and educational purposes only. Kindly go through this slide fully. Let's move on to the problem question. We have to consider the potential liability of Adam for the criminal attempt in each of the following scenarios. Eve gives Adam a package at the airport which, as he tells him, contains heroin. In fact, it contains talcum powder. Adam is arrested on arrival in the UK and charged with attempting to import a controlled drug. Adam, believing that Eve will not consent, has intercourse with Eve, who in fact was willing and happy to have intercourse with Adam. Eve, a police officer, offers Adam, whom she believed to be a fence, someone who makes their living from buying and disposing of the stolen goods. A large quantity of scrap laid at an undervalue. Adam buys it, suspecting it may be stolen. In fact, the lead is not stolen. The fourth scenario, Adam wants his wife, Eve, to die knowing that Eve has a heart condition which makes her vulnerable to fatty foods. He takes charge of the cooking in their household. Every meal that he makes for her, he ensures contain excessively large quantities of animal fats. A year later, Eve dies in an unrelated car accident. To determine Adam's liability for the criminal attempt in each of these scenarios, it is necessary to analyze the elements of the attempt under Section 11 of the Criminal Attempts Act 1981. The Criminal Attempt Act requires that is more than merely preparatory to the commission of the offences and the mens rea of intending to attempt, commit that offence. The first case, attempt to import heroin. Adam's liability for attempting to import a controlled drug hinges on whether his actions meet the actus reus and the mens rea of the criminal attempt. The actus reus is satisfied if Adam's action were more than merely preparatory to the importation of a controlled drug. In R versus Jones case in 1990, the court held that an act is more than preparatory when the defendant embarks on the crime proper. Adam's transportation of the package satisfies this threshold. The mens rea requires an intention to commit the offense. Adam believed the package contained heroin, demonstrating the requisite intention. The fact that the package contained talcum powder is irrelevant under the principle established in the case R versus Shivapuri in 1987 case, which held that impossibility does not preclude liability for attempt. Therefore, Adam is liable for attempting to import a controlled drug. In other words, Adam has been charged with attempting to import a controlled drug under Section 1 of the Criminal Attempts Act 1981. According to this section, a person commits a criminal attempt when they intentionally engage in acts that are more than preparatory to the commission of an offense even if the offense itself does not occur due to impossibility. The case of R. versus Shivapuri 1986 case is directly relevant here. In Shivapuri, the House of Lords confirmed that a defendant can still be guilty of attempting a crime, even if the crime was impossible to commit. In Shivapuri, the defendant attempted to smuggle a substance he believed to be heroin which was actually harmless, and the court held that he could still be guilty of an attempted offense despite the impossibility of the crime. In this scenario, the Adam believed that the package contained heroin and he acted on that belief by attempting to import it. Even though the package contained talcum powder rather than heroin, the act of attempting to import the substance still constitutes an attempt under Section 11 of the Criminal Attempt Act 1981. Therefore, despite the impossibility of the crime, Adam is liable for attempting to import a controlled drug as per Shivapuri, attempting to commit the rape. In this scenario, Adam's liability for attempting to commit a rape depends on whether he intended to have intercourse without Eve's consent and whether his actions were more than preparatory. The actus reus of the attempt requires an act that goes beyond mere preparation. Adam's intercourse with Eve satisfies these elements, as it constitutes the physical act necessary for the offense. However, the mens rea is not satisfied because Adam's belief about Eve's lack of consent was incorrect, and the Eve was willing and happy to have intercourse. As established in R versus Khan in 1990 case, the mens rea for attempted rape includes an intention to have the intercourse and the knowledge or recklessness as to the lack of consent. Since Eve consented, Adam lacked the mens rea for attempted rape. Consequently, the Adam is not liable. In other words, the Adam engaged in intercourse with Eve, believing that she will not consent, when in fact she is willing and happy to have intercourse. The key issue here is whether Adam can be charged with attempted rape under the Section 11 of the Criminal Act 1981. The establish an attempt. The Adam must have had the mens rea, the intent to commit the rape, undertaken more than the preparatory steps towards committing the offense. The case of R versus Con in 1990 case established that to attempt the rape, the defendant must intend to have a sexual intercourse without consent. However, in this case, Eve did not consent, which means there was no actual rape. Despite Adam's belief that Eve would not consent, the impossibility of the offense does not preclude the liability for the attempt. As confirmed in our versus Shivapuri case, the impossibility does not negate the charge of attempt if the defendant had the intent to commit the offense. Here, Adam's belief, though mistaken, constitutes an intent to commit the rape, and he took more than the preparatory steps by engaging in the act of intercourse. Therefore, he is liable for attempt rape under Section 11 despite the impossibility of the offense, since the EU consented. Let's analyze the third scenario, the Adams attempted handling of stolen goods. Adams' liability for attempting to handle the stolen goods depends on whether his actions demonstrate an intention to handle the stolen property and whether his act was more than preparatory. By purchasing the ledge, the Adam performed an act that satisfies the actor's rules of an attempt as he took steps towards committing the offense. The mens rea requires that Adam intend to handle the stolen goods. In Orr versus Shivapuri case in 1987, the court held that an individual can be liable for attempting to commit an offense even if the object of the crime is not as they believe it to be. The Adam suspicion that the lead was stolen demonstrates a degree of recklessness, but suspicion alone is insufficient to establish the intent. As held in R versus Mohan case in 1975, an attempt requires a direct intention to commit the substantive offense. Thus, Adam may not be liable for attempting to handle the stolen goods. In other words, the Adam is suspected of attempting to handle the stolen goods. The Section 11 of of the Criminal Attempts Act 1981 requires that a person take steps more than the preparatory to the commission of a crime with the mens rea to commit the offense. The key issue here is whether Adam's intention to handle the stolen good is sufficient to constitute an attempt. In R versus Khan case in 1990, the court made it clear that for an attempt, the defendant must have the required mens rea for the offense. For the offense of handling stolen goods, the required mens rea is either knowing or believing that the goods are stolen. Adam suspects that the goods may be stolen but does not know or believe it. In R versus Maxwell case in 1978, confirms to be guilty of attempting to handle the stolen goods. Adam must have the knowledge or the belief that the goods are stolen, and since he only suspects, he lacked the necessary mens rea for an attempt. Therefore, although R. Adam took steps towards acquiring the goods, he cannot be guilty of attempting to handle the stolen goods as he lacked the required mental state. We are moving to the final scenario, attempting to cause Eve's death. The Adam's liability for attempting to kill Eve depends on whether his actions were more than preparatory and whether he intended to cause her death. The Adams act of preparing the high fat meals satisfies the actor's res as it demonstrates steps taken towards achieving this goal. The mens rea recurs an intention to kill Eve. The Adams deliberate inclusion of excessive animal fats in the Eve's meals, knowing her heart condition, evidence this intent. However, the causation element is problematic here as Eve's death occurred due to an unrelated car accident. Following the principle in R versus White case in 1910, Adam's action must be factual cause of the harm. Since Eve's death was not caused by Adam's action, he is not liable for the murder. Nevertheless, the impossibility of achieving the intended result does not absolve him of attempt liability under R versus the Shivapuరి case in 1987. Therefore, Adam may not be liable for attempting to cause Eve's death. In other words, the Adam's attempt to cause the death of his wife, Eve, by deliberately cooking the food with excessive animal fats, knowing that Eve has a heart condition that makes her vulnerable to fatty foods. The issue here is whether this constitutes an attempted murder under Section 11 of the Criminal Attempts Act 1981. The key elements of the criminal attempt are the actus reus, taking more than the preparatory steps, and the mens rea, the intended to commit the offense. R versus White case in 1910 established that taking more than the preparatory steps is sufficient to constitute an attempt, and in this case, the Adams action, intentionally cooking the food with excessive fats, represents more than the mere preparation for causing the harm. The mens rea for attempted murder because the intent to kill or cause the grievous bodily harm, as in R versus Moloney case in 1985. Adam's intent to kill Eve can be inferred from his actions as he knew that the excessive consumption of the fatty food could be a fatal for her due to heart conditions. However, the issue is whether his actions, which are relatively indirect, that is, the cooking the foods, amount to an attempt to kill. In Orr versus Cunningham in 1957, the court held that recklessness could be sufficient for the manslaughter, but that direct intent is required for the murder. Here, although Adam may have intended to cause harm, his actions, such as the cooking the food, might not meet the standard for an attempted murder charge, as they do not reflect the immediacy or the certainty of the death required for an attempt. Thus, Adam may be charged with attempted murder due to his deliberate actions, but the issue of whether these actions, particularly the indirect nature, of the cooking food meet the standard for attempted murder remains complex and would likely require further analysis. To conclude, the Adams potential liability of the criminal attempt in these scenarios largely depends on the mens rea and the actus reus elements of the offense. In the scenario A, Adam is liable for attempted importation due to his intent to import heroin despite the impossibility of the offense. In scenario B, Adam is also liable for attempted rape due to his intent, even though the EU consulted. In scenario C, Adam cannot be convicted of attempting to handle the stolen goods because he lacked the necessary mens rea. In the scenario G, the final one, Adam may be liable for attempted murder based on his intent to cause the harm to Eve, though the indirect nature of his actions might complicate the charge. Thank you.